So can anyone here tell me what these percentages signify?
Indian Education Society.
Okay, so the top percent, 60%, that's the historical data of district courts. A district court has held a patent valid 60% of the time. This is historical data. That second number, 21%, signifies historical data of the number of times or percentage at which a PTO has deemed all the claims in a patent to be valid. So I mean, there's a big difference there. These numbers, Kumar kind of touched on this. $2 million to $8 million is the cost of an average patent litigation in the United States. $200,000 to $400,000 is the average cost, what we're seeing of these new proceedings, these new IPR, CBM cover business method, mostly IPR proceedings. 2.5 years is the average pendency of a litigation, where you're going to determine infringement, you're going to determine validity. 1.25 year is how fast the PTO rules on validity. So if you take your case to the PTO, if you're a defendant, you're going to get a decision sooner, for cheaper, and you're going to have a better shot at winning, of invalidating a patent if you're a defendant. And from the plaintiff's side, unfortunately, it's not all good news, but as Kumar said, I mean, the hope is that these proceedings are used to weed out the bad patents as opposed to the good patents. But that number, that 21% number I threw out is historical data from re-exams. If you look at IPR, there have only been 2 decisions that have come out of the PTAB with respect to inter-parties review, and the petitioner, the defendant, the alleged infringer, has won both times. So none of the claims have come out of an IPR as of now, based on the 2 decisions we have. None of the claims have come out as valid. So, you know, Congress kind of saw the problem that Kumar was talking about, which is, you know, there are a lot of bad patents out there in the system. How do you clean it up, right? So they said, well, going through the district court is probably not the best way because it's too expensive, and it gives rise to a lot of litigation misconduct where you have these patent trolls, in essence, holding up these companies for a few $100,000 or even a few $1,000s worth of settlement. So they wanted to create a new procedure that would provide a faster, less costly alternative to civil litigation, as Senator Chuck Grassley said, right? And the House of Representatives, who's the Congressman Bob Goodlatte said, look, when such a defendant company truly believes the patent asserted is invalid, it is important to have an avenue to request the PTO to take another look at the patent. So they wanted to take this decision away, in essence, from the district court and put it back to the PTO. So we live, I mean, part of this changing landscape is we live now in a world where a patent never really leaves the patent office. Before, it used to be that the PTO used to grant the patents and the district court used to determine the validity of patent infringement. But now, I think we're entering a time when a patent never truly leaves the patent office. And this approach of having the PTO decide validity is somewhat justified. Just to kind of reiterate some of these stats, percent of times that a district court finds patents to be invalid is about 40%. PTO is about 79%. Once again, these are re-exam stats. And in the EPO, it's about 40%. So this is kind of the progression of how this whole thing came about. Until 1981, litigation was really the only way to invalidate a patent. From 1981 to 1999, there was this avenue of ex parte re-examination. Congress saw that it was working and they wanted to make it a little more robust, so they created this inter-parties re-exam. And that went into effect in 1999, lasted to 2012, and they saw the success of the inter-parties re-exam, and so they made it even more robust by introducing this inter-parties review, post-grant review, and covered business method proceedings. And so I'll just refer, for ease, I'll just refer to to those as the inter-parties review, the post-grant review, and the covered business method as USPTO patent trials, because that's really what they are. They're mini trials regarding validity of patents. So what are the advantages of these patent trials? Well, they apply to all unexpired patents. It's a bench trial of validity in front of 3-judge panel as opposed to the examiner, as re-exams were. There's a full participation by third-party requester, the petitioner. Discovery is very limited, and discovery, as you probably all well know, is what contributes to most of the cost of a district court litigation. And here, the PTAB, the Patent Trial and Appeal Board, has really cut down on what kind of discovery you can get. Patent owner's ability to add claims are very restricted, and the duration of proceeding is fixed by statute. They have 12 months after institution to come up with a decision. And here's the kicker. When you couldn't settle, before you couldn't settle one of these PTO proceedings by settlement. Now you can, and that gives great leverage to these petitioners. And the appeal goes directly to the Federal Circuit, while before it had to go from the examiner to the PTO appeal board and then to the Federal Circuit. And I think we're seeing success rates will probably be very similar to inter-parties re-exam. Here's the table. I won't go through it, but here's a table kind of listing what's involved for each of them. I mean, the one thing I will point out is inter-parties review is limited to arguments of invalidity based on patents of printed publication under 102 or 103. When the post-grant review and covered business, when post-grant review comes into play, it's going to involve all grounds of invalidity. And I guess let me just say this as well, and I'll touch on it a little bit later. This estoppel provision, everybody's worried about this estoppel provision as a reason, and they give that as a reason for why they don't want to start one of these proceedings. Because the estoppel applies to all issues raised or which could have been raised during third-party review, meaning you can't raise those issues at the district court. But in my opinion, as I'll show later on, I think it's a meaningless situation. I don't think it's something to be worried about, frankly. Here's the trial. Petitions filed. There's a patent owner's preliminary response, and then the PTO decides whether to institute one of these proceedings or not. And then once it's instituted, that 1-year timeline kicks in. The PTAB has to decide within a year. What we're seeing based on the recent IPR decisions is that, in fact, the whole process is only taking a year instead of the allocated 18 months. So the PTAB is narrowing the issues, and they are coming out with decisions very quickly. So where do you want to be, right? I mean, so if you're a defendant sued for infringement, where do you want to be? So location, location, location. Do you want to be in district court with lay judges and a lay jury who are going to determine infringement and validity issues? Or do you want to be at the PTAB, panel of 3 judges who are all JD, who are all patent attorneys, and who all have technical degrees? So what this avoids is in front of the jury, as Kumar probably can tell you, in front of a jury and a judge, there's a lot of theatrics. It's a morality play. Who's right? Who's wrong? Those are the issues that ultimately win the day in front of a jury trial. You avoid all that at the PTAB. These judges are very substantive focused. They only look at the prior art, and then they're going to decide based on the prior art. There's really no room for theatrics, and it really doesn't have any impact, and they try to cut it out. So once again, I mean, the trial appeal board, this is the composition of it. Settlement, let me just touch on that. It terminates the USPTO review without trial, and the key is that if you settle a case at one of these IPR proceedings, there's no estoppel. So you're not estopped from raising it at another, another case or at a later on date. And given the statistics at which we're seeing the PTAB invalidate patents, when you file one of these things and the PTAB institutes one of these proceedings, it gives the defendant great leverage. There's a credible threat of invalidation here. So, for example, if you take this situation applied to generic pharma companies here. If they file one of these proceedings and it gets instituted, the branded companies even more scared now than if they were in district court in their home jurisdiction. It seriously levels the playing field for the generics. And the terms, as with settlement agreements and litigation, the terms can be kept confidential. So coordinating with litigation, well, how do you coordinate with it? The USPTO trials now has caused this parallel path to exist, right? So you have the district court action, there's discovery, there's a trial, there's a decision by a judge, whole thing takes 2.5, 3 years. So here's your USPTO trial. Trial's initiated, there's a decision within a year, and then if the patent is found to be valid, there's limited discovery and you're going to go try the infringement issue alone. If it's invalid, there's no trial, and if there's a settlement, I mean, it depends on what the settlement is that defines how you go forward.
Does that mean the finding of the PTAB is binding on the district judge?
Yeah, that's a good question.
Because you say it proceeds only the trial, which means that finding is binding on the judge.
That's a very good question. So there is a case called Fresenius that's just come out, and it's a landmark case, and it basically says that if the PTO invalidates a patent, that's binding on the district court. So you can go all this way. So in Fresenius, for example, the patent owner won significant amount of damages, and then the PTAB invalidated the patent. So that controlled.
But at the same time,